Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to a special Smarter Lawcast podcast episode in which we're going to examine Australia's human rights and international law obligations in relation to climate change harms and the export of fossil fuels. In August this year, the Australian Human Rights Institute's Climate Accountability Project released a substantial research report called State of Denial, which examines these obligations. My name is Nathan Kennedy and I'm a partner at Hall & Wilcox, a co-lead of our ESG practice and head of our Pro Bono and Community program. I'm delighted to be joined today by my guest, Gillian Moon from the Australian Human Rights Institute, who co-authored this report. Welcome, Gillian.
Hello, Nathan, and thanks so much to you and to Hall & Wilcox for inviting me to this conversation.
It's a pleasure. So let's start at the beginning. What motivated you to undertake this research, and why did you feel it was important to focus on Australia's fossil fuel exports and human rights obligations?
I think I'm like many people in that in recent years I've become more and more aware of our deteriorating weather and the way extremes of weather are coming not only more frequently, but they're more intense. Just to name a couple, I personally experienced the massive Moreton fire in 2020, which was well beyond anyone's capacity to control. And more recently, a close friend was hit hard by Cyclone Alfred, which came so much further south than previously. And I came to understand that as one of the world's largest fossil fuel exporters, my country is a big contributor to what's happening to us through this deteriorating climate that we're seeing in Australia. But I also realised, talking to people around me, that most of us think of Australia as a little guy when it comes to driving climate change. Most people have very little awareness of the significant contribution of our coal and gas to the extreme weather that we're experiencing here and to the increasingly common disasters in Australia.
Yeah, I think that's right. I think most people don't seem to understand what our exports are like. They do just look at Australia as a fairly small player in relation to climate change and greenhouse gas emissions. So you do highlight in the report that, like you said, we are one of the world's largest fossil fuel exporters, and we've got exported emissions that far exceed our domestic ones. So for our listeners who might be in law, policy, or industry, can you explain the scale of Australia's exported emissions and why this is so significant for our national and international responsibilities?
Australia is the world's second largest fossil fuel exporter when we measure by life cycle carbon or CO2 emissions, and that places us behind only Russia and ahead of every OPEC state. We produce and we export large volumes of coal and gas, and coal is an extremely climate-damaging fossil fuel. So overall, our fossil fuel exports are responsible for around 3.5% of global fossil fuel carbon emissions each year. And this may look like a small percentage, but it's actually a huge quantity of carbon dioxide. And we can measure the exact fractional temperature rise which these emissions, are causing each year. Our coal and gas exports are measurably driving up the world's average temperature. They're measurably warming our own climate, making weather disasters, megafires, and big floods more likely to occur and to happen on a scale rarely seen until now.
And we, like you said before, see that happening in Australia especially. And I guess the reason people think we're such a small player is we only talk about our domestic emissions and claim we're only responsible for those domestic emissions. We don't really talk about the exported fossil fuels. How does your research respond to the argument that might be put forward by the government that our only responsibility is our domestic emissions?
So this particular claim by Australia is really confusing people, and it's acting to draw attention away from the fact that we're a world-leading fossil fuel producer and exporter. And I'll explain what I mean. Under Article 13 of the Paris Agreement, the world's nation states, have agreed to keep a central inventory of greenhouse gas emissions emitted each year. So collectively, we can keep track of where we're all at and where we're heading temperature-wise. And to make sure that this is done with the greatest accuracy and avoiding double counting, the system is that each state reports the emissions which occurred within its territorial boundaries. But Australia has chosen to pretend that means it has no obligations of any kind to take a portion of responsibility for the harms resulting from its exported coal and gas emissions, which are more than 3 times those emitted domestically. So it's saying that the Paris bookkeeping system is some kind of super declaration of all international law obligations of states to prevent dangerous climate change, which is so very far from the case. In fact, states have agreed under the Paris Agreement to put forward their, and I quote, utmost ambition to keep the world well below 2 degrees, and the highly developed, wealthy states like Australia have expressly agreed in the Paris Agreement to take the lead. So Australia's international law obligations under the Paris Agreement are in no way, shape or form limited to this bookkeeping exercise of documenting emissions. And I'll be talking a bit later about what those international law obligations of states in fact are. But I'll just say this, that they cover the entirety of Australia's actions causing harm to Earth's climate system, not just those emissions released domestically within Australia.
And you certainly argue in the report that Australia's current approach does place it in breach of its international human rights obligations. So we might begin to unpack that. Could you outline what Australia is doing, and I guess crucially what it is not doing, to protect human rights in the context of climate change?
I'm glad to say that Australia is not doing too badly in getting its domestic greenhouse emissions down and transitioning its economy across to renewable energy and at least getting off coal. But we are continuing to produce very large volumes of coal, and over 90% of this we ship overseas, and also large quantities of gas, and more than 3/4 of the gas we produce is also exported. And as background to this, Australia has constantly refused to establish any regulatory framework to address these ongoing exports. This means that we have no cap on the export volumes. We have no export reduction targets. We have no plan of any kind for the future. And we don't have any phase-out dialogues with our buyer countries either, almost all of which are wealthy countries, Paris Agreement parties like Japan, Korea and Taiwan. Instead, what we're doing is continuing to issue new fossil fuel licenses and project approvals, almost all for export, and some of these extend out as far as the 2070s. We're continuing to provide billions in financial supports to these projects, and we insist on excluding these exported emissions from our national mitigation frameworks like the Safeguard Mechanism. This position of policy and regulatory denial is becoming increasingly untenable for Australia, and one reason for this is the sheer pressure from climate change itself. More and more evidence is coming forward to show that every fractional increase in Earth's average temperature results in escalating human harms, including in Australia. And let me mention just 2 examples. In 2022, the IPCC, the International Agency of the Climate Scientists, projected that heat-related excess deaths in Brisbane, Sydney and Melbourne will increase by between 300 and 600 per year. That's an increase per every year over the period 2031 to 2080. At present, the deaths caused by heat in Australia, including in combination with humidity, which is also rising, are under-recorded because they tend to be attributed instead to the medical emergency which the heat triggered, such as a heart attack or a stroke. One university meta-study in 2019 found that heat-related deaths in Australia have been so grossly underestimated that more than 36,000 deaths occurred between 2006 and 2017, which were in fact attributable to heat, but weren't recorded as such. Let me mention another example, which is another university meta-study just this year, which confirmed a significant association in all places around the world between exposure during pregnancy to excessive heat and a predictable increase in preterm births, low birth weight, stillbirth, maternal mortality, preeclampsia miscarriage, and gestational diabetes. So mounting evidence of this kind is creating a lot of pressure for Australia to develop a credible plan for bringing down, over time and in a managed way, its full contribution to the damage that its fossil fuels are doing. But another reason that Australia's position is becoming increasingly untenable is that legal pressure is building, especially since the International Court of Justice handed down its advisory opinion in July this year. Given the sheer scale of Australia's contribution to climate change, the risk of interstate, that state-on-state legal actions, has risen greatly this year as a result of that advisory opinion. But just a final point on your question, Nathan, it's also clear that the human harms that I've mentioned that we're increasingly experiencing here in Australia are also human rights harms. And this opens up a new area of state obligations, international architecture and procedures, and litigation prospects.
Yeah, it's definitely having an impact on people's health and lives, and obviously states under an obligation to protect the right to life and the right to people's family and home lives and welfare. But of course, in Australia, we have no national Human Rights Act. So what are our human rights law obligations in the context of the fossil fuel exports and their impacts, given that there's no domestic protection as such?
Human rights law obligations enter the legal landscape at two levels in Australia. So the first is the domestic level. Australia has two coal-producing states which have enacted human rights statutes, and that's Victoria and Queensland. And I think we'll begin to see more use being made, particularly in Queensland, of this emerging and building human harms evidence, which is establishing or helping to establish that human rights are increasingly being impaired in Australia as our climate worsens. And also that these two states are not taking appropriate action, to being big coal-producing states, to address that. At the international level, Australia's a party to all the major international human rights treaties, those treaties require it to be especially vigilant and to take the necessary measures to protect human rights of people within its territory against real and foreseeable threats of harm, including those arising from business activities like fossil fuel production, and regardless of where the greenhouse gas emissions from that production actually occur. Now, Australia's known for some decades of these very real climate-driven threats and harms to human rights, to those within its territory. And it has both the capability to reduce the threat and it has available to it reasonable measures that have a real prospect of making a difference for us. This means that Australia's failure to take action to minimise the worsening harms to us from these fossil fuel exports places it squarely in breach of its international human rights law obligations. In the advisory opinion of the International Court of Justice, the judges were very clear on this point, that a state like Australia, which has considerable unused capability to intervene and minimise risks, that a state like Australia must take all necessary measures to protect the climate system on which the court concluded the realisation of all human rights depends.
That was a very significant finding, I think. And it'd be good now, I guess, to look more at that advisory opinion, it's been described as a turning point for international climate law. Could you give us a bit of background about how that advisory opinion actually came about?
Yeah, it's actually a remarkable story that began, in fact, 6 years ago, when a group of Pacific Island students, law students, persuaded their governments to propose that an advisory opinion be sought from the International Court of Justice that would set out the international and clarify the international law obligations of states to prevent harmful climate change. And this is unusual. When the proposal was put to the UN General Assembly a few years later, after a great deal of preparation and consulting and lobbying over a number of years, the General Assembly agreed and made a formal request straight away for an advisory opinion on two critical questions. And if I can summarise and paraphrase these, the questions were in the contexts of international customary law, the law of the sea, international climate law, and international human rights law. First, what are the obligations of nation states to ensure the protection of the climate system from man-made greenhouse gas emissions? In other words, what are states required to be doing now to protect the climate system? And the second question was, what are the legal consequences under these obligations for states where by their acts and omissions, historically, they've caused significant harm to the climate system? In other words, what does the law say about reparations for damages already experienced or already locked in now?
And for our listeners who mightn't know as much about international law, what made this opinion so significant?
It's a question of where to start with that, because the advisory opinion is significant in so many ways. But let me just mention a few that I see as particularly relevant for Australia in terms of its international human rights law obligations when it comes to the fossil fuel exports. And the first is simply just that the International Court of Justice went beyond expectations in that it's now clarified so much of the law that Australia can no longer be in doubt as to what its legal obligations are. And while this is an advisory opinion, it's not a judgment from a contested matter, and it's not technically binding law on Australia. It is the unanimous opinion of the world's most authoritative legal source on the subject. And added to this, the court did a masterful job in integrating all of those separate bodies of international law into a clear and coherent set of state obligations. And a second point, as I've just mentioned, is that one of the main arguments Australia put before the International Court of Justice in the hearings has been shown by the court to be completely wrong. Australia argued that meeting the quite limited emissions reporting requirements of the Paris Agreement, like its reporting its domestic emissions and lodging its nationally determined contributions periodically, are all that it's obliged by international law to be doing in the climate space. But the ICJ judges made crystal clear that much more is required. To begin with, the court said that all states have a binding international law duty to prevent significant harm to the climate system from man-made greenhouse gas emissions. And this is because Earth's climate system is fundamental to successful human existence. The court drew on the science to reach that conclusion. And what this conclusion means for Australia is that just going along as we are, we're exporting large quantities of fossil fuels, taking no responsibility for the damage they're causing to Earth's climate, having no plan at all to address them. That places Australia in clear violation of international law and international human rights law. A third reason I think the advisory opinion is so significant is that the ICJ made clear that it doesn't matter where the emissions from burning our fossil fuels occur, whether it's here in Australia or overseas. The court expressly warned that failure by a state to prevent significant harm to the climate system may constitute an internationally wrongful act, which is attributable to that state. And this is the case whether the harm results from that state's actions or from the actions of fossil fuel corporations operating in its territory. So if I can just draw this point out, the wrongful act is not the act of emitting greenhouse gases per se. It's the breach by Australia of its international law obligation to protect the climate system from the significant harm which will result from these greenhouse gas emissions. Now, Australia has fought really hard over this issue in legal fora and diplomatic fora and in the climate negotiations, but the law is now beyond argument. Australia is responsible if it has failed to take the actions reasonably available to it to prevent significant climate system damage caused by the fossil fuels produced by companies operating from its territory. A fourth point that I think is really significant is that states are required by international human rights law to undertake a series of steps to comply with those legal obligations that I've mentioned. This is referred to as states undertaking their due diligence to ensure they're meeting their legal obligations at all times, and most lawyers will be familiar with this concept in the context, of course, corporations law and directors' duties. For nation states, due diligence similarly has to begin with investigation, with finding out exactly what harm is being caused to the climate system and to people and to their human rights by actions in a state's own territory or under its control, and also investigating what's being done to prevent that. And then if I can quote from the ICJ again, states must then use all means at their disposal, including the adoption of appropriate rules and measures to prevent activities carried out within their jurisdictional control from causing significant harm to the climate system. Now, the ICJ made clear that highly developed, high fossil fuel producing states like Australia stand out as required to adopt particularly strong and effective rules and measures. All states must design these rules and measures so that they can ensure that deep, rapid and sustained reductions of greenhouse gas emissions occur that are necessary to prevent the harm. And just following on from that, I think my fifth significant point is that there are now clear steps which Australia is obliged to take if it's to do what it's required to do and comply with international and human rights law from this point. Step one is that it must establish an immediate moratorium on approvals of new or expanded fossil fuel projects and grants of financial support, because this is clearly where it strays into internationally unlawful acts. Pending decisions made, of course, in the course of its due diligence investigations, subject to what it finds out about the harms that are occurring, their attribution to Australia's actions, and what Australia is actually doing to minimise the harm. So step two is it must immediately begin its due diligence. And this involves undertaking a comprehensive assessment of the contribution of its exports to climate harms and climate-related human rights harms in Australia. And these include assessments of Australia's historical, current and projected exported fossil fuel emissions and of their temperature effects. So Australia has to conduct a review. It has to conduct this investigation, and then it has to conduct a review of its current policies and regulations at both the national and subnational levels. And it needs to identify the steps it can reasonably and effectively take to minimise or reduce the harms which are clearly occurring as we speak. The third step is that it has to develop a regulatory and policy reform package. It can't be doing nothing. It can't be producing this large quantity of fossil fuels for combustion and have no policy or regulatory framework, no plan for reducing the harm that it's essentially causing to Earth's climate system. And step four, it has to ensure that throughout all of this, it behaves in a way that fully respects human rights. Perhaps one final point to add that's significant from the ruling is that it confirms that climate change is more than a legal problem. So the judges concluded, and I quote again, that climate change is an existential problem of planetary proportions that imperils all forms of life and the very health of our planet. And unfortunately, as the ICJ demonstrated in the setting out of the scientific evidence, this is not hyperbole or individual opinion. It's a conclusion based on the climate science alone.
And it seems like in response to this opinion, nothing much really has changed in terms of Australia's policy, particularly in terms of putting in place any of those steps that you outlined there. There seems to be a real risk to Australia that it could be challenged based on what the law is. And of course, there are challenges to challenging the state, particularly, and that is outlined in your State of Denial report, particularly in enforcing human rights protections in the climate context, and particularly, as we've mentioned before, with Australia's lack of a federal Human Rights Act. So it'd be good to have a look now into the main barriers to legal remedies for people affected by climate harms and what reforms you might recommend to make it easier for people to enforce their rights in this context.
Well, this is the big question right now, and there's probably no single answer because it's complex. I'd say that in general terms, the main barriers probably lie in the difficulties establishing the chain of causation first, and secondly, in the shortage of specific domestic laws creating liability by greenhouse gas emitters for their harmful impacts. To go to the first, the causation difficulty relates to uncertainties that are inherent in the process of climate deterioration. So we know, for example, if I can explain, we know the exact fractional temperature rise which any given volume of carbon emissions will cause, and we know the increase which that fractional temperature rise will cause in the likelihood of extreme weather events. And we can even make confident predictions about the adverse effects of each of these on specific demographic and social groups identified as vulnerable. So we know that with every temperature rise of a certain fraction, there will be a predictable increase in, say, heat-related deaths of people with diabetes or heart disease. But what we can't yet readily do is take the next step, which would be to say that this individual will experience harm of this type at this time. And the second main barrier I see relates to, as I said, laws establishing liability for the harms from carbon emissions. By and large, Australian courts have declined to find a novel basis in tort for climate-related claims of harm. And in the absence of something like a price on carbon, it's difficult to compel fossil fuel companies to carry the losses for the harms their products are causing. But that said, it's a dynamic field, and there are rapid developments in attribution science which are enabling further links in that causal chain to be firmed up. For example, a team of Australian climate scientists last month published in the peer-reviewed journal Nature Climate Change a robust methodology for quantifying the adverse impacts from the emissions of individual fossil fuel projects. And this methodology and others also being currently developed will quite rapidly, I think, strengthen both the chain of causation and causation arguments and attribution of responsibility as a consequence.
And yeah, you can really see the improvements in attribution science, and that really, the stronger that gets, definitely it would seem the more risk there is for governments, but also for fossil fuel companies themselves. And we have talked about the government a lot, but not so much about these fossil fuel companies. So what are the legal and reputational risks for those companies if they just continue business as usual in light of these international developments? And what practical steps should companies be taking now to align themselves with international law and avoid legal risk?
The Advisory, in my opinion, there's two important things to say in that regard from the advisory opinion, although others specialise, of course, in this area of corporate law. And the two that I see is that the advisory opinion has substantially increased regulatory risk for fossil fuel companies operating here, given that it's made clear that Australia's failure to regulate them in any way and continuing to provide financial supports to them are in fact internationally wrongful acts.
Mm.
And parallel with this, those developments in attribution science that I mentioned, which are now coming through, mean that these companies will no longer be able to deny the causal connection between the use of their products and escalating climate harms and resulting climate-driven losses. So, as I see it, the days of being able to describe their environmental and social impacts as negligible because they're merely a drop in the ocean of emissions are already over. The advisory opinion makes clear that the IPCC science, that's the global body of scientists, doesn't support this drop in the ocean approach. And with the emergence of these methodologies, attribution methodologies that I mentioned, the risk that obfuscation by a company will be judged as misleading and deceptive has risen steeply. So fossil fuel companies need to be frank about these raised risks, but more than anything, they need to be developing genuine transition plans into different models, different business models, and they need to be starting to implement them right now.
Yeah. And your report set out a 4-step reform process for Australia, which we've touched on, I think, before. What would it take for Australia to implement these recommendations, and what are the biggest obstacles, whether they be political, legal, or economic?
What Australia is now clearly required to do, the most important step is, without doubt, that it's obliged to take, if it wants to comply with its international law obligations, is to stop its actions which are making significant harm to the climate system worse. This means it must stop approving new coal and gas projects. It must stop providing royalty waivers and subsidised infrastructure and so on for these projects. And it must stop its active promotion of its coal and gas to buyers in our region. When it comes to obstacles to action, one of the biggest that I see relates to misinformation and spin about the consequences if we start to wind down our fossil fuel export sector. And this is because there's a widespread belief in Australia that our fossil fuel export sector occupies a much greater place in our economy and our economic future than it actually does. And this misunderstanding is acting to protect and promote ongoing state inaction and promote ongoing climate damage. For example, in addition to the existing government subsidies, some studies undertaken in Australia have demonstrated that aspects of Australia's fiscal regime for oil and gas production have allowed many operators of major projects to pay very little or nothing in royalties or resources rent taxes. And even though Australia produces such large quantities of fossil fuels, another thing that's not widely understood is that its economy is actually services-based and quite diverse. It's certainly not particularly fossil fuel dependent. Australia ranks a long way back in the global list on this measure, which comes out periodically. And another exaggeration is the number of jobs in the fossil fuel industry, which has been repeatedly inflated. So I think that there's some fact correction about the role that this sector plays in our economy that also needs to occur, which is currently acting as an obstacle to Australia implementing its obligations.
Maybe we can go back to the ICJ opinion to have a look at, there were some separate opinions and declarations in that opinion. It's hard not to say judgment when you're talking about a court's decision. And they talked about the impact on vulnerable states and communities of climate change and the need for solutions. Is there anything that any lessons Australia should learn, including its policymakers and maybe also fossil fuel companies, from the perspectives of the separate opinions that would give it?
Yeah, it's correct that a number of the ICJ judges wrote separate opinions on particular points, and many people have alighted on those with great interest, and they are very interesting. But my view is that the most significant thing to appreciate here is the advisory opinion itself, that it was unanimous, and unanimous opinions of the ICJ are rare. And it's this fact which gives the opinion such great persuasive weight. It's also a particularly authoritative, clear and direct statement of states' legal obligations to protect Earth's climate system. I think it's hard to look past the advisory opinion itself, which does so much and is such an excellent statement of international law. I think keep in mind too that the judges who added their separate opinions were all wanting to set out their even stronger conclusions as to states' obligations. None of them wrote with the aim of weakening or winding back in any way the conclusions about state obligations in the opinion itself. They all wanted it to have gone even further.
Gillian, I think this has been a really fascinating conversation and really informative. There are obviously obstacles to progressing things, and sometimes, certainly with climate change, people can get a bit despondent. I'd be interested to hear from you. What gives you hope? What are the signs of progress either in Australia or internationally, obviously, in addition to the advisory opinion, and that suggests we can close the gap between our legal obligations and our actions on climate and human rights?
What gives me hope is that I'm fortunate to be engaged in a project which is breaking open the silence around Australia's real role in driving climate change and climate-related harms here in Australia. We're working in a collaboration with climate scientists, public health people, demographers, lawyers, and we're building the evidence base of human harms in Australia which are attributable to our own actions. And in doing this, in bringing additional certainty and clarity, we're helping people here in Australia to understand how much harm we're in fact bringing on ourselves by continuing with these fossil fuels, but also that we have the power of control over something that is significant, that can make a difference. So I'm really pleased to be helping to throw off the cloak of silence, to raise awareness in Australia of what our government is doing so that all people can have a say about these emissions and minimising the harm that climate change is bringing on us.
Thanks, Gillian. Thank you very much for being with us today. Your report and this conversation really sets out clearly the science and the harms that climate change can cause, but also the very clear legal obligations, particularly international and human rights law legal obligations that states and companies have, and the real risks that face governments and companies if they don't start to put in place some plans to comply with those obligations and start to reduce greenhouse gas emissions and reduce harms, importantly, being caused by climate change. So thanks everyone for listening today. As always, please get in touch with us if you have any questions. You can find our details on our website, which is hallandwilcox.com.au, or connect with us on LinkedIn. If you enjoyed today's episode, then rate, review, or subscribe to our podcast wherever you get your podcasts. Thank you.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.